wabarakatuh. Good morning to you, Hannah. My pleased to record. My name is Hairi Ibrahim, counsel for the appellants Amnani. This case about between Puan Aminah and her daughter Amnani, with Amnani as a plaintiff and Puan Aminah as a defendant. The case is about defendant want to give her land to her daughter for birthday present, but there is no consideration the contract between Puan Aminah and Amnani.
Assalamualaikum warahmatullahi wabarakatuh. May it please the Honorable Court. Good morning, Your Excellence. My name is Hamzan bin Rashidi as the lawyer for the defendant Puan Aminah. This is a contract case between the defendant Puan Aminah and her son Amnani, where there is no consideration in the contract.
Honest lady and gentlemen of the jury, the issue in the case is whether the contract between Aminah and her daughter Amnani is valid, void or voidable because there is no consideration in the contract. Relating to this case, the contract between Aminah and Amnani is void because there is no consideration in the contract between Puan Aminah and Amnani. When at the design of the promisor, the promisee of any other person has done or abstaining from doing or does or abstaining from doing or promise to do or to abstain from doing something such as or abstaining or promise is calling a consideration for the promise. Based on definition, Amnani did give any in return to Aminah. Therefore, there is no consideration as in the contract between Puan Aminah and Amnani. According to Section 26A of the Contract Act 1950, an agreement is made by Puan Aminah and Amnani is void because the contract between Aminah and Amnani is no consideration. In the case of the Ran Tan Song Sim v Tan Song Kyong 1951, court has adopted Chinese custom. Custom said that adopted children are considered to be near related with their adopted mother and adopted sibling, but not with their adopted mother sibling. Therefore, the agreement is void. It failed to fulfill Section 26A. Related to our case, the contract between Puan Aminah and Amnani also don't have consideration in the contract. Based on this reason is the case of the Ran Tan Song Sim and Van Tan So Kyo 1951, the court should have that the contract made by Puan Aminah is void. This is because there is no consideration in the contract between Puan Aminah and Amnani.
Honorable members, ladies and gentlemen, the problem in this case is whether the contract between Puan Aminah and Amnani is voidable and valid because there is no consideration in the contract. In relation to this case, the contract between Puan Aminah and Amnani took place because Puan Aminah was made in good faith to resolve the problems that occurred between the two parties amicably. At the desire of the promiser, the promisee or any other person has done or abstained from doing or does or abstains from doing or promises to do or to abstain from doing something, such act or abstinence or promise is called a consideration for the promise. Based on the definition, Amnani didn't give anything in return to Puan Aminah. Therefore, there is no consideration exists in the contract. According to Section 26A of Contract Act 1950, the agreement made without consideration is invalid unless in writing and registered is stated in writing and registered under law if any temporarily compelled to register such document and made due to good intention and conviction between the two parties. Pursuant to Section 26A of the Contract Act 1950, the agreement made by Puan Aminah and Amnani is valid contract because the contract is made because of good intentions and beliefs between the parties who have close relationship between each other. Ramsgate Victoria Hotel vs Montefiore 1866. Montefiore applied for shares on June 8, but he was notified until November 23 that his offer had been accepted and that the share had been granted to him and that the balance of share debt was now due. Montefiore refused to pay and the company threatened to sue with breach of contract. The court ruled the action of Ramsgate Victoria Hotel for certain performance was unsuccessful. The offer made by defendant in June is not longer valid to enter into a contract. A reasonable period of time has elapsed and the offer has expired. The court states that what will be classified as a reasonable time for the offer to expire depends on its subject matter. In this case, it was decided that 6 months was the appropriate time before the termination of the stock offer automatically. However, for the other property, this will be decided by the court in each of these cases. In our case, the contract between Puan Aminah and Amnani was also made on the basis of the good faith and fairness between the two parties of each other. Based on the decision in the case of Ramsgate Victoria Hotel, the court should hold that the contract made by Puan Aminah is valid. This is because was made in good faith and fairness between the two parties who are close to each other.
Johanna, I refer the argument from defendant. My argument based on why contract is plaintiff or defendant is void because the contract was made with no consideration based on the section 26A of Contract Act 1915. An agreement made is void because there no consideration in the contract between Puan Aminah and Amnani. Conclusion. In the case, the contract between Puan Aminah and Amnani is void because there is no consideration because Amnani will not paying any money to his mother. Pursuant to section 26A, an agreement without consideration unless this is written or registered. In connecting with our case, Puan Aminah did not make an agreement with Amnani regarding his birthday gift and also was not considered by Aminah. Result in the contract Tan Son Sing v Tan So Kyong 1951. The courts adopted Chinese custom. Custom that adopted children are considered close to their adopted mother and adopted relatives, but not to their adopted sibling. Therefore, the agreement is invalid. It failed to comply with section 26A. Amnani must return the land to Aminah. For this reason, I respectfully request that the court be in favor of the respondent and take the specific action and state in the warning to uphold justice in the case.
As the conclusion in this case, the contract between Puan Aminah and Amnani is valid because Puan Aminah want to give her land to her daughter for Amnani birthday present. According to Section 2A of the Contract Act 1950, when one person signifies to another his willingness to do or to abstain from doing anything with a view of abstaining the essence of that order to the act of abstinence. Related to our case of good faith and belief that Puan Aminah wants to give the land to her daughter Amnani on her 21st birthday, Puan Aminah is worried that the transfer of her land to Amnani will be cancelled because Amnani refused to pay to her mother. Therefore, Puan Aminah is worried that the transfer of her land to Amnani will be cancelled. Based on the judgment in Ramsgate Victoria Hotel vs Montefiore 1866, contract Puan Aminah is valid because her want to give the land to her daughter for birthday present.